law, as an acronym, is a group of over 250 constitutional and human rights lawyers who have, over the years, distinguished themselves in the defense of constitutional and human rights within the confines of the Nigerian law. Over the past few years, too, Nigerians have looked forward to our interventions and positions on several salient national issues, prominent among which are issues regarding the laws of our lands and our roles as legal practitioners. The timing of this conference is of great importance, considering the fact that the nation is still battling with the fallout of the various elections, from presidential to National Assembly, governorship, and the State House of Assembly polls. Accordingly, many salient issues regarding the place of the rule of law in our struggling democracy have been thrown up. At our meeting, we started around 8 p.m. on Monday and ended in the early hours of today, Tuesday. The need to protect the integrity of the judiciary as aggrieved political parties and their candidates approach the court was top on the agenda, bearing in mind the fact that ours is not a perfect society, but our imperfection can be corrected by the strict adherence to the rule of law, especially the decision emanating from our courts. Other issues raised were the need for candidates and political parties to be conscious of the need to preserve Nigerian democracy by adhering to the provisions of the law guiding post-election matters. Politicians were advised against sponsoring crises across the nation to demonstrate their grievances, as sponsoring post-election crisis will negate the supremacy clause of our Constitution as stated in Section 1, Sub 2 of the 1999 Constitution as amended. Rather, every aggrieved individual or groups of individuals who wish to govern Nigeria or any part thereof should give total consideration to Section 1, Sub 2 of the 1999 Constitution, and anything to the contrary will amount to subversion of the supreme law of the land. Thus, any aggrieved individual should seek judicial redress as enshrined in the Constitution. The worrisome trend of disobedience of court orders by officials saddled with the responsibility of piloting the affairs of the nation at different levels was also discussed at our meeting. The Nigerian Constitution, which is the foremost origo, the frontest origo of the Federal Republic of Nigeria, and our legal system and the foundation of its government, to this end, its provisions are believed to be sacred and binding on all authorities and persons throughout the Federal Republic of Nigeria. In addition, Section 9 of Part 1 of the 5th Schedule of the Nigerian Constitution states clearly that a public officer shall not do or direct to be done in abuse of his office any arbitrary act prejudicial to the rights of any other person, knowing that such act will unlawful or contrary to any government policy. The above provision of our Constitution point to the fact that the Nigerian Constitution specifically bars public officers from acting in ways that may be oppressive to a citizen of the Federal Republic of Nigeria. The Constitution also, without prejudice to specific public office or officer under reference, bars public office holders from acting in ways that may be considered unlawful and contrary to any government policy. Furthermore, one of the cardinal tenets enshrined by the Constitution is the principle of separation of powers, where each arm of government, to which legislative, judiciary, and executive, is an equal partner in the running of a successful nation. The Nigerian Constitution, which is the frontest origo of the Federal Republic of Nigeria, and our legal system and the foundation of its government, to this end, its provisions are believed to be sacred and binding on all authorities and persons throughout the Federal Republic of Nigeria. It is for this reason that we are constrained to speak on some recent actions of subversion of the principle of separation of powers and the rule of law by some agencies of the federal government of Nigeria, some of which have attracted the fury of Nigerians across the civil society, media, and even eminent senior lawyers, who consider the act of the disobedience to the rule of law particularly the orders of our court, as an assault on our constitution that the president and every appointees of the government in Nigeria has sworn to uphold and defend. We believe that the persistent abuse of power by public officials in Nigeria is an aberration which has attained notoriety as part of the fabric of our society. We wish to state that equality before the law is the only true protection against the specter of oppression and undue influence that those in position of authority would otherwise dangle over the heads of ordinary Nigerians. You will recall that it took the direct intervention of President Muhammadu Buhari for the governor of Central Bank of Nigeria to obey a lawful judgment of the Supreme Court, the highest court in the land, on the Naira redesign policy of the CBN. This was after the flagrant disobedience to the preliminary judgment of the same Supreme Court before the presidential election were held. Even now, our meeting agrees that the federal government has not fully complied with the judgment with regard to other aspects of the policy, which has continued to put Nigerians through untold hardship. Another disturbing example of one of those institutions that have become notorious for totally disregarding the sanctity of our court and continuously infringing on the human rights of citizens is the Economic and Financial Crime Commission, known as the EFCC. The implication of the continued disregard for Nigerian judiciary and disobedience to our laws are beyond individual victims or the integrity of these agencies. Both at home and abroad, this badge of shame stains our collective national consciousness and makes daily mockery of our Nigerian laws. Our over 250 members have therefore urged President Muhammadu Buhari to, within the limited time left in the life of his administration, urgently address the dangerous culture of disobedience to the rule of law, assault on our judiciary, and ultimately ensure appropriate sanction for the violators of the dictates of our Constitution. In conclusion, we are stating that a country that has no regard to the decision of its court is heading towards anarchy. Hence, we call on the National Judicial Council to direct all courts in the country to henceforth not entertain any case brought before them by any agency of the government who are found of disobeying court orders, especially EFCC, until the chairman of EFCC, Mr. Abdulrasheed Bawa, has purged himself by obeying all subsisting court orders binding on him. As an official whose conviction was made by an order of a court or court of competent jurisdiction, we do not consider him fit to continue presiding over the affairs of law enforcement agency, especially one constitutionally set up to fight corruption. You cannot use the corrupting influence of power to enforce anti-corruption laws. We consider it a ridiculous aberration that a convict will be in charge of getting others convicted when he should be serving time for contempt of court and when there has been no superior judgment against the conviction. Finally, we wish to use this opportunity to announce the constitution of a new leadership for the association, which is to be led by Barrister Godwin Idoko, President, Barrister Suleiman Gwamba, Vice President, Barrister Gaius Inaligu, Secretary, Barrister Genesis John, Publicity Secretary, and Barrister Ann Ikuta Onyeke as Welfare Officer. Nigeria is under a democracy, and all forms of impunity must be tackled by those who genuinely love our country and are interested in the survival of our democracy. The rule of law cannot be selectively applied.